Believe it or not, at times, lawyers will file these motions on the eve of trial or even on the morning of trial. And why do they do this? For the worst possible reason, because they can. There's no deadline in the rule except before or at the arraignment, which is universally ignored. And the fourth DCA in Acosta Figueroa ruled that that motion can be filed at any time before trial. So the court, of course, can fix this. We propose that immunity motions to dismiss must be filed no later than 30 days before the trial. Of course, there's a good cause exception, and there will be good cause.
All right, quick context so this hits the way it is supposed to. This is the Florida Supreme Court taking up a proposed rule change that could reshape how motions to dismiss get filed in criminal cases, especially stand your ground immunity motions. The core issue is simple. Some of these motions are being filed at the last second, right before the trial. And the court is weighing the deadlines, sworn testaments, and whether this is about fairness or gamesmanship. Listen closely for the line that basically sums up the whole controversy while some of these get filed so late. And watch how the judge responds.
Sometimes we'll ask for an immunity hearing just to get extra discovery, because the more times you have a hearing, then the more inconsistent statements you're going to have. It's just kind of inevitable. And the other thing that they can do is they can wear down a witness's cooperation, because if you stop and think about it, they have to give statements to the police, state attorney investigation, maybe a grand jury, depositions, immunity hearing, and then the trial. And a lot of these involve drug deals gone bad, where everyone has a gun and somebody shoots somebody because somebody gets disrespected or whatever, or they're gangs that are shooting at each other. So the chances of getting these witnesses in every single time is not very good. Obviously, if it's a good faith immunity hearing, we have the immunity hearing. That's the law. But I think we should just have an assurance that it's made in good faith, and that
people swear, like the defense be able to rely on the sworn statement as evidence in the hearing.
Yeah, that's our proposal. Just that it's a motion, it's sworn. There could be an affidavit by another witness. It can be the defendant swearing to it, like what happens in a C4 motion. I mean, just a swearing like that. And then our proposal would be, okay, here it is. It's sworn. State, you have the burden of proof by clear and convincing evidence, and you go. Now, that's not exactly what the Freeman court says, but we're not proposing anything that far. The Freeman says that the defense has to put witnesses on at the hearing. That may be dicta, but they said it. So
essentially the statements could take place of any live testimony in your mind, right, or in the motions.
Right. Now, all it has to be is an unsworn motion. So, all right. Thank you. And
sworn statements, forfeiture, and good cause. Sworn statements. I believe the committee's proposal, if I heard the judge correctly today, he's proposing to essentially reinstitute a C4 procedure for immunity motions, which I believe this court ruled was inappropriate in Dennis. That the judge would look at these motions and make a decision based on the motions to whether you ever get a hearing. That, of course, is not what the statute says. Statute says that your prima facie case is made at hearing. And frankly, if you can't come up with your prima facie case at your hearing, then it's a very, very short hearing.
How would you respond then to the committee's argument that there exists essentially a circuit split on this issue, and that if we sort of don't deal with it in amending the rule, we're sort of whistling past the graveyard?
I appreciate the committee's position. I'm not sure there is actually a circuit split, but that aside, the circuit split, if it exists, is on what happens at an evidentiary hearing. Neither Freeman nor Jefferson nor any other case in Florida that I know of suggests that there needs to be a sworn motion before the hearing. There needs to be some sort of showing of prima faciality to even get to a hearing. The legislature said very different. The legislature said, and this is the language out of 776.0324, prima facie motion raised by the defendant at a pretrial immunity hearing. That's the statutory language. And I would urge this court to follow that statutory language. That's what the legislature did. That's sworn motions. I'm going to move on to forfeiture unless the court has other questions. This proposal is that motions to dismiss would be decided on a procedural forfeiture rather than on the merits. This is antithetical to everything I know and have ever read about Florida law. Florida law always wants every case decided on the merits.
But all sorts of substantive rights that parties have are constrained by procedural limitations.
They are constrained by procedural limitations, Your Honor, but I can't think of any other place in criminal law, certainly, where we have crime, justice, punishment, liberty at stake, where a procedural...
I understand the argument, that incarceration is categorically different, but one might argue that in other areas of law, losing your life, your business, your child, that's all, and everything's constrained by procedure.
Well, it is constrained by procedure, but I can't think of any place where it would be decided, where a meritorious motion would be procedurally forfeit.
What about 3851?
Let me think through that. That's post-conviction, Your Honor.
But
That's a very different...
Justice Sasso's point is correct that, there's, due process means process. And so, I think your argument proves way too much. It can't be that we don't have some filtration mechanism in the rules for saying this claim, for example, is foreclosed because it has been forfeited. Now, that doesn't say that we don't review ultimately for fundamental error. But it does mean that the rule says that a successive, effort at making an argument that was available to a party at an earlier time operates as a prima facie forfeiture.
Your Honor, and particularly in post-conviction, I think that might be different. I mean, quite candidly, the finality of convictions changes the legal landscape quite significantly. But in this context, I would ask very strongly for the court to not build into the rule the forfeiture. The current rule, although...
Do you think the immunity motion could be raised in the middle of a trial?
No, Your Honor, because immunity is from going to trial. So by definition...
Well, it would be from continuing trial, wouldn't it? It just seems like your argument about forfeiture just proves way too much because there's not actually a forfeiture of the defense. The defense is still available, correct?
Well, some defenses may be available. But...
assuming it's raised. Again, the defense can be forfeited. If you don't raise it appropriately in the trial, you're going to lose the defense, right?
Yes, that is true, but it's not decided on a procedural forfeit.
Batson. There's another example of it. If let's say you reach the end of jury selection, and you think, oh, I should have struck this juror for Batson reasons. I'm gonna reopen. I hereby I'm asking the court to reopen jury selection before we swear the panel. The court says, I'm sorry, we're not reopening jury selection. It's that would seem to me to be a pretty good example of how you've got a constitutional right, and yet we have a process. And if you didn't speak up at the right time, I'm sorry, counsel, we're moving forward.
Okay. Let me backtrack and make an argument that might be more palatable to the court. Let's not make that the forefront of the rule. The current rule is pretty good. It has there's a waiver if you don't, but then the exceptions basically say for any fundamental or actually any motion you would care about. That's why the judge says we don't pay that much attention to it, because the exceptions cover everything you would care about. And I think that that's the appropriate rule.
All right, that's the debate. On one side, the court and the prosecutors are saying last-minute filings can throw the whole system into chaos. On the other, the defense attorneys warning that strict deadlines can block real arguments from being heard on the merits. So I want to hear from you. Should the court enforce a hard deadline on stand your ground cases, or should it be allowed at any time before a trial? Drop your takes in the comments. And if you want more Florida Supreme Court clips like this, make sure you subscribe. I've got another one coming.